Whereas the respondent contends that both applicants do not have fixed places aboard because they did not provide land titles or tenant agreements to show the fixed places of abode, and therefore they may not be located or held accountable if they jumped bail. Counsel for the applicant submitted that both first and second applicants provided evidence in support by each applicant about their respective fixed places of abode. In the case of the first applicant, he provided 2 locations at Buyinja LC1, Wampeo, Ward, Kasanga Town Council, Wakiso District, and Rwakabengo A, Rwakabengo Ward, Southern Division, Rukonjiri Municipality in Rukonjiri District. And in the case of the second applicant, the location is Isigula Village, Cell, Mutundwe Ward, Gombola Savagabo, Makindye Wakiso District, also within the jurisdiction of this Honorable Court. Regarding pending charges, counsel for the applicant submitted that the second applicant has no pending charges against him, and that the first applicant having a pending charge at Uganda Road Court cannot be used to dismiss the second applicant's application as submitted by the respondent. Counsel further stated that the respondent in fact, the first applicant has been put on his defense or found guilty, that he does not cease to enjoy the constitutional presumption of innocence because he has a pending case. Counsel for the applicant stated that the fact that the first applicant was charged with current offense while on bail in respect of the Uganda cannot be used against him, and it is the same state that charged him that is now using those charges to argue that he should not be granted bail, alleging he reoffended while on bail. Regarding the possibility of interfering with witnesses and investigations, as for the applicants submitted that in Panju versus Ara 1973, Volume 1, East African Road Courts at page 282, it was held that the allegation of interference with witnesses must be substantiated and that such substantiation is not difficult to show. I also submitted that there is no evidence that there has been placed before this court by the respondent to show that the alleged strong likelihood of interference with the witnesses or investigations. Also prayed that this honorable court finds no likelihood of the respondent on this point. While submitting in respect of applicant's age, the answer submitted that the courts can, and in this case, should take judicial notice that prisons are not holiday destinations. That the fact that there are harsh conditions on remand has been taken note of, including in cases cited by the respondent, such as the case, Augustine case. In respect of possibility of absconding, it was submitted for the first applicant and second applicant that since the arguments of the respondent seem to focus more on the first applicant, then the argument should not prejudice the second applicant, and that the evidence of the first applicant's mastery of the game, presumably fleeing from Uganda, is not supported by any evidence. Also further submitted that the first applicant has demonstrated that in the past, when released on bail, and he required to travel outside the prison, he only undertook it with permission of the court. He would go out of the country and return. Regarding the sureties, it was argued for the applicants that the sureties presented were advised about their role of by the honorable court, and none of them protested or said that they were unable to perform their roles. In Kawanguzi Sereko David versus Uganda, criminal miscellaneous application number 426 of 2023, the court held as follows. It is my considered view that is not designed as an income generating avenue for courts to which bail applications are made. What is pertinent about sureties is that there must be indication that they have been advised of their roles as sureties. They identify themselves properly and have shown and proved their authoritative relationship in respect to which the applicant showing that they are able to exercise their authority and command the appearance of the applicant in court when needed. As for the applicant, informed court that the sureties had been informed of their duties in respect of bail, which duties they understood well and committed to executing. As the proposed surety is required to provide a copy of his or her national identity card, and B, an introduction letter from the local class 1 chairperson of the area where the surety is ordinarily resident, as provided under bail guidelines. Council further submitted that the ages of the sureties, which ranges from 27 to 58, demonstrate adult persons capable of understanding what they are undertaking, and that none is a minor and none is a person of extreme old age. Therefore, all sureties have provided these documents, citing the case of Chigongo versus Uganda, criminal application number 7 of 2024, cited justice dispensed, particularly the informal nature of the employment of the majority of Ugandans, that makes it difficult to possess documentary evidence of capacity to meet monetary obligations. To insist on documentary proof of capacity to meet monetary obligations in the event that the state is called upon to fulfill the bond, surface of the population from the opportunity to stand surety for relatives and friends. This would not amount to against a section of the society on the basis of their socio-economic class. The courts have long held the view that if courts are to simply act on allegations, fears, or suspicions, then the sky is the limit, and one cannot when bail would be granted when allegations are made. As for the applicants submitted that they respond to provide no evidence to rebut the grounds relied on by the applicants in support of their applications. It was prayed for the applicants that this honorable court finds that the applicants have each satisfied the requirements in the law and on the applicable facts to enable this honorable court to exercise discretion in their favor and release them from custody on bail on reasonable terms. Determination. 1. Analysis of the law and the evidence. Article 23, 6A of the Constitution provides that where a person is arrested in respect of a criminal offense, the person is entitled to apply to the court be released on bail, and the court may grant that person bail on such conditions as the court considers reasonable. Although the Constitution guarantees an accused person the right to apply for bail, the court at all times retains the discretion whether or not to grant an accused person bail. See Foundation for Human Rights Initiative versus Attorney General, Constitutional Petition number 20 of 2006. The primary principle for which a court may release an accused person on bail pending trial is the presumption of innocence. This legal principle is enshrined in Article 28, Subpart 3 of the Constitution. The person who is charged with a criminal offense shall be presumed to be innocent until proven guilty or until that person has pleaded guilty. Section 15(1) of the TIA, in addition to upholding the right of accused person to apply for bail, clothes this court with the discretion to release an accused person on bail at any stage. The principles include the presumption of innocence, the right to liberty, applicant's obligation to attend the court, the discretion of the court to grant bail on such terms as the court considers reasonable, and the application. The right to apply for bail and the court's discretion to grant bail. This grant has already been addressed as above, and it is clear that the applicant has the right to apply to court to be released on bail, with the court having the discretion whether or not to grant bail under Article 23(6) of the Constitution. Presumption of innocence. The principle of presumption of innocence is a constitutional one, and as noted above, the bail guidelines require this court to consider the principle of presumption of innocence and personal liberty in determining bail applications. In relation to personal liberty, the active principle in granting bail is that of upholding the liberty of the individual while simultaneously protecting the rights of justice. Subsection number 20 of 2016. The presumption of innocence means that an accused person should not be taken in custody and deprived of his freedom unreasonably. Bail should not be refused merely as a punishment, as this would conflict with presumption of innocence. Fixed place of abode and substantiality of sureties. Fixed place of abode. A fixed place of abode for an applicant must be within the jurisdiction of this honorable court, as it guarantees the court that the applicant's accused person cannot be found can be found in the event of absconding. It is therefore imperative for the court to be persuaded that the accused person has a fixed place of abode, because it is a pointer to the fact as to whether the applicant is likely to abscond once granted bail. Section 16, subsection of the TIA is